in to reform that system to have a lot of ability to experiment. And the difficulty with unions, even in the private sector, but particularly given their additional advantages in the private sector, is they make it very much more difficult to innovate in public goods. And that is actually going to harm equality. It's not rich people who benefit from public education. It's people who have less resources that are dependent on public education. And so the most important thing is to make that education most effective. And the difficulty is that it's not surprising that the workers in that their interests are not exactly aligned with that objective. And so that is the problem here. Now let me get very briefly to the constitutional issue. In some sense, I'm very happy I began with Franklin Delano Roosevelt, because since the New Deal has been very clear that while civil rights are substantially protected, and so absolutely people have the First Amendment rights of association, to protest, economic rights, which would include those rights of collective bargaining, are dealt with in the Constitution on the basis of a rational basis. So long as there is a rational basis by which a decision is taken about economics, about how to deal with your union on the other side, no court is going to disturb it. And I think that is somewhat, indeed, I think is a somewhat frivolous argument. There, in fact, are a variety of states without collective bargaining. No one has argued that they are acting unconstitutionally. And finally, I just disagree with the previous speaker that it's best for us simply to always have stability. What I think democracy is about a variety of experiments. A variety of experiments in governance. Some things work, some others do not work. And we learn over time with that experience. And the problem with collective bargaining in something like the teaching context is it makes those experiments more difficult. And certainly the problem with any kind of constitutional rule that we can't experiment with the nature or degree of collective bargaining would strike at the very heart of a democratic system, its ability to learn from experience.
Thank you, John. Tammy. I'll start my comments here. I think it's generally accepted, even among my fellow panelists to the left, that there is currently in constitutional jurisprudence no constitutional right to collectively bargain, and that right cannot come out of the individual civil rights of assembly, speech, association, or the right to contract. So I start with that in saying because there is no constitutional right or natural right to bargain collectively regarding wages and benefits in the public sector, that in this debate on this public issue, it's really the burden of persuasion must be on the advocates for public sector collective bargaining rights to convince us all that it is something of value. Collective bargaining for public employees, as noted, is a fairly recent development, being the first state in 1959 to recognize and give public sector employees the right to bargain was Wisconsin. By 1970, about half of the public sector employees had some collective bargaining rights. Let me give you some facts. I like to come with facts. Collective bargaining for public employees is not, even today, absolute or universal. According to a 2009 Congressional Review Service, 24 states had given all public sector employees the right to collectively bargain. An additional 17 states allow some public sector employees to bargain, such as teachers and police. 9 states have either no laws or affirmatively prevent collective bargaining in the public sector. Even in those states that have granted collective bargaining rights, often those rights are limited, as mentioned, with prohibitions against strike. Some states do not provide the public sector employees the right to binding arbitration, and there are often limits on the subject of bargaining, such as enforced in the federal government, where federal employees do not have the right to bargain collectively over wages and benefits, but instead those are set by Congress. Thus, I start with the proposition that any debate on this issue, the advocates for granting public sector employees' rights really do have the burden to convince us that the benefits to the public, and not just to the public employees, but to us, the public and the taxpayers, outweigh the costs to the public. And I will disagree with my fellow panelists on the costs, because there are costs for granting public sector employees the right to bargain collectively. Although there are different sources and studies, depending on your point of view, it is clear that collective bargaining in the public sector does result in significantly higher wages as compared to the private sector. I was on the BLS webpage today, and if you go and look at the 2009 National Compensation Survey, which is available at www.bls.com, you will see reports of median wages of both private sector and public sector employees, unionized public sector employees versus non-unionized public sector employees. And what you will find is that unionized government workers have their median hourly wage is 31% higher than earnings in the private sector and 22% higher than their non-union government employee counterparts. The specific numbers is that the private sector employees have a mean hourly earnings of $20.18. Non-union state and local government employees have a median hourly wage of $23.01, and unionized state and local government employees have a median hourly earnings of $29.13. Now let me address directly the idea that there really is no pay gap here, because these are mean-to-mean numbers and do not correct for educational degrees. 2 points. One, as a Republican woman and an endangered species in this I'm a definite minority today. But I'll get through it.
Okay.
I have been fighting for years against the numbers we hear every year about the pay gap between men and women, which always compares average to average, mean to mean, without correcting for any educational degrees or even experience in the workplace. So part of me says, wow, if we're all now going to change and say it's not acceptable to compare mean to mean, I'm all for that, and guess what? There's no pay gap if you correct for those things between men and women. I know, it's a little pet peeve of mine, side thing. But the real important is, I read the study that corrected for education, and they actually found, what I read was that, in their opinion, the difference was actually negative 11%. Of the public sector unionized employees being 11% less than their private sector counterparts because of correction of education. The problem with that study is that they did not go far enough, and they did not correct for the type of degree. Okay? In the public sector, most people with degrees are teachers, social workers, people with degrees in public policy or public administration, and you simply cannot compare those directly to engineers, lawyers, doctors, hard scientists, computer programmers. And so I think that study is just not valid. I did look, wait 2 more minutes, I know. The Cato Institute did the study. They say the difference is plus 10%. I think that's probably the closest that we'll get. So there is a cost. So then the question is, what is the benefit to the public of granting public employees the right to collectively bargain? And not to the public employees, but to the public, us, but to higher wages. Oh, one other factor. In the public sector, 95% in a 2007 BLS survey found that 95% of state and local government workers had traditional defined benefit pension plans, as compared to only 21% in the private sector. That is huge cost that us private employees, most people in the private sector these days are very lucky if their employers match their 401ks. So what is the benefit to the public? For this cost. In exchange, I'm an American. I want value for my dollar as a taxpayer. In exchange for the higher taxes that result in the higher costs of wages and benefits, I want better government services. I want proof, that the higher wages and benefits means better government services to me. And I think that the advocates of public sector bargaining really do need to convince me of that. A final point, and then a suggestion of how I think we could resolve this controversy. The historical reasons for creating the right to bargain collectively in the private sector, in my opinion, do not justify public sector bargaining. And let me talk about the points raised by my opponent on the panel. Historical mistreatment of employers and better working conditions. Well, one, today, unlike in the past, we have OSHA, Title VII, minimum wage and overtime laws, child labor, and in the federal governments, in many state governments, service, thanks to unions. You're absolutely right, thanks to unions. No problem. We also have civil service protections which protect employees in government from those asshole managers that we all know are out there. But let me give you an example of that. When I was a federal government manager at DOL, I was told I couldn't fire an employee who called in sick and was arrested the next day in a getaway car in a bank robbery. Okay? So, and also, don't forget we're talking about state and local governments here. And taxpayers, us, there is not a history of governments forcing employers to work massive hours without fair compensation and under unsafe conditions. That type of history that you see in the private sector isn't there. Is it necessary to ensure fair wages and benefits for government employees? I say no, because BLS data shows that that's not the case. And further, federal employees don't bargain over their wages and benefits, and I've heard no federal employee complain that they're not paid well enough or that their benefits suck. Finally, to even the bargaining power between management and labor, I think John dealt with that. The balance of power is simply different in the public sector because the party who bears the cost of those increased wages, unlike in the private sector where the shareholder has representation at the bargaining table, a taxpayer, us taxpayers, we do not have representation at the bargaining table. And so although we bear the cost of this collective bargaining, we do not have a say in the collective bargaining. And that leads to my suggestion, and then I'll close. Perhaps the middle ground for resolving this controversy is to give the taxpayer a more substantial role and more power at the bargaining table. Union members have a voice, even if they're not directly at the bargaining table, through their right to ratify and vote in favor or against the new collective terms of the new collective bargaining agreement. I say let's not end collective bargaining. Let's not end collective bargaining even over wages and benefits for government employees, but instead let's give the taxpayer the same right to vote up or down on increased wages and benefits through referendum. Thank you.
Thanks, Tammy.